Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to another episode of Legal Ease, the channel that converts legal jargon to legal ease. Tonight we have an extremely interesting topic, and that is the use of mediation as in dispute resolution. I'm privileged to be joined by two experts whom I will introduce a little bit later, but just by way of background, in the Muslim world, mediation is known and recorded as the first act when Nabi Sallallahu Alaihi Wasallam utilized his skills as a mediator by placing the black stone in the middle of the sheet, and in that way he was able to bring the tribes to peace, so that he utilized those services effectively. So tonight we have with us Afzal Mosam, an advocate who is practicing at the Johannesburg Bar, and we have Ebrahim Patelia, an attorney who is practicing in the Johannesburg area. Afzal, assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum salam. Ashraf, thanks for having us.
And welcome, Ebrahim. Assalamu alaikum.
Wa alaikum salam. Ashraf, thank you for the opportunity.
Thank you for joining us. Afzal, you're a specialist in this field, and you have lots and lots of experience in various organizations, including doing training in the field of mediation. What is mediation?
Well, mediation in simple terms is where parties to a dispute get an independent person to try and resolve a dispute between them. So the mediator is not judgmental in any way. The mediator merely listens to both parties, and the sole interest that the mediator has in the dispute is to settle the dispute.
Ebrahim, what's your understanding of mediation?
I think mediation brings a unique opportunity for people to take the opportunity to resolve a problem themselves. Because at the heart of it, human beings by their very nature have conflict. I mean, it is something we don't like, but we have it, and we don't like dealing with it. We often want to refer it out. Now, what mediation does, instead of referring it to a third person to make a decision on the matter, it allows those very people who are the owners of the conflict to sit down and try and find a solution that they're happy with. And once they're happy with the solution, in fact, there is a greater likelihood that they would stick to that solution.
No, what Ebrahim raises is important, because what happens in mediation is you have control over the outcome of your dispute. So as mediators, we call it a win-win situation,
right,
where both parties come to an amicable resolution that they're both happy with, as opposed to adjudication, which is like when you appear in a court of law and a third party makes a decision which you've got to accept. Either party has to accept. So you get a winner and a loser. And in simple terms, at mediation, you get a win-win situation where both parties are happy.
So in other words, there is a distinct difference between the various forms of dispute resolution. So you spoke of litigation, for example, where people have to go to court. Arbitration is another method. So mediation counts amongst various methods. But what got you interested in mediation personally?
Well, a number of reasons. I think you mentioned Nabi Sallallahu Alaihi Wasallam's first interaction with the tribes of Mecca. But more importantly, if you look at the history of Islam, the tribes of Medina approached Nabi Sallallahu Alaihi Wasallam, and he mediated between them. And as a result of that, that gave rise to Islam flourishing when the Muslims performed hijrah and went to Medina. That's one of the reasons. The other reasons is I've always been involved in the labor field, and I've always had good relationships between both employers and trade unions. And it was a natural progression to get involved in mediation, and I've been doing it since.
So obviously, I mean, you have a very, very long history with this particular skill. And for you, Ebrahim, what brought you to be a mediator?
I think one has to ask the question, can anyone be a mediator? I think the one thing that keeps people continuing to mediate, because it's an unforgiving profession, is that you need to have the soul of a mediator. It must be a calling, something that you love to deal with, because you get up in the morning and you're actually going to deal with conflict continuously. And I think what Afzal talks about is also true, is that through a life experience or an opportunity, and mine was being exposed through mediation very early on in my career as a disillusioned lawyer, and then realizing that this was for me, because I could assist people in resolving conflict. I found my calling, so to speak, and from there progressed through various experiences. And similar to Afzal, started off mediating very simple labor disputes, and then took this further and saw the opportunities that mediation could bring in resolving conflict.
Now, Afzal, particularly in your field, which appears to be dealing with conflicts on an extreme level, if I may just take an example, the present mining disputes. You've been involved in some of these very high-profile matters. Can you talk us through some of these processes, just in a few steps?
Look, yes, I've been fortunate enough. I've dealt with the public service strike. I've dealt with the strike in the gold industry. The present strike in the platinum industry, I was the private arbitrator that mediated between the respective trade unions, and Anglo-American and Lonman. So I've been fortunate enough to have this opportunity to do a number of disputes.
And having acted for plaintiff and defendant at different times, that must have brought a fair amount of skills to you. And how did that assist you, acting for both parties?
Look, when you are dealing with what we call mutual interest disputes, that is disputes relating to wages and conditions of employment, there is no arbitration involved. It's only if you are deemed an essential service that you would have to go to what we call interest arbitration. Look, it's an experience you gather over time. And as you do different processes, you learn more about how to resolve issues. So that's the background I can give you relating to these kind of disputes.
And both of you have picked up immense training and expertise along the way. Both of you are certified commercial mediators, which takes a lot of training, and I think the training was done from experts from London, and have been involved in various training mechanisms and programs of your own. Ebrahim, tell us a little bit about your training program. You do train mediators with skills.
And I think that's, the transition in terms of what mediation was and now is an important one. I think, Ashraf, you raised a point earlier on about mediation being one of the options in terms of dispute resolution. And I think what we see now is that when we have conflict, whether it's a civil claim, a divorce matter, a labor dispute, how we react to that claim is important. There must be an appropriate response. So just before I get to your question, Ashraf, is that we see now mediation as one of the appropriate options that people have. So we need to go through a process of rationalizing and thinking what is now appropriate for our clients if we are lawyers. So a lot of the work that I have done is to develop skills in younger lawyers through legal education and divorce mediation training amongst practicing lawyers. And also with the CCMA to train mediators, because I think there are different levels to it, Ashraf. It's not only training people as mediators. Often we talk about mediation as a magic panacea to cure all evils, but it has a particular role, and if used appropriately can deliver results. And I think there's a lot of room to talk to people about how to actually use mediation appropriately. Because if you use mediation in all instances, it will fail and you will be disillusioned by mediation. So part of the initiative, I think myself and Afzal and a number of mediators who are passionate about it, try and continuously develop those skills, firstly on how do we use mediation, secondly, when do we use mediation, and obviously, how do people actually become a mediator? And I think that's the spectrum of training. But there's a lot more that can be done, because the beauty of being a mediator is understanding how conflict is managed. And if you understand how conflict is managed, you often can assist people to determine how they manage everyday differences that they have.
So with regard to training and passing on the training to the community at large, Afzal, I understand that you've been involved in training the Somali community in the mediation process. Tell us a little bit about that and what kind of benefits it's brought to that particular community.
Well, the Somali community is pretty organized, as you would gather. And we were approached to train the higher council. We conducted the training over a period of three days. The process of mediation is utilized in the Somali community to deal with commercial disputes, to deal with matrimonial disputes, to deal with family disputes. And it seems to be working pretty well.
So what you're actually saying is they actually have a very strong structure that allows and makes mediation possible. Because I think the underpinning reasoning behind this is that there must be some respect for the process as well as for the person who is the actual mediator. Ebrahim, I know that you're a founding member of the Muslim Mediation Arbitration Council, which is a joint initiative by the Jamiat Transvaal, as it was then known, and a group of lawyers, and it's based in Johannesburg. Tell us a little bit about the Muslim Mediation Arbitration Council and what it does, how it functions, and what areas of law or processes it would cover.
The beauty of mediation is that it can resolve all types of disputes. And I think the one thing we recognize is, as you both have introduced mediation, is that it is part of our religion. It should be an immediate response to resolving conflict. So the initiative was introduced many years ago to try and offer an alternative at that stage to normal court processes. So people could then utilize a process of mediation by selecting a mediator of their choice. So if they wanted an alim, they could choose an alim. If they wanted to choose a lawyer, they could choose a lawyer. It was a voluntary, it is intended to be a voluntary process. So you select the mediator of your choice, you select the time that you want to have the mediation. When I say you, I mean both parties involved in the conflict. So they both must agree to this. And then the process of mediation is offered with a standard that must be applicable to any dispute that we would get. Even if Afzal is mediating the platinum conflict, that was the intention, to offer a perfect system of mediation. But also the MMAC offers an arbitration facility as well. So if parties did not want to sit down and resolve their conflict, and also didn't want to go to court and wanted an alim of their choice, again a lawyer of their choice, or anybody of their choice to arbitrate a matter to get to a final decision, the MMAC could provide that particular service. And
so let's say you reach a decision and in one of these fora. Does that have the power of law? Is it binding on the parties?
With mediation, the parties need to conclude if they are agreeing with the settlement agreement. And dependent on the type of dispute you're dealing with, typically those parties could go to court and make that settlement agreement an order of court and enforce it. But it would be a binding contract, to put it simply. Arbitration would be governed by the Arbitration Act of South Africa. We cannot act outside of the legal system that we have applicable. And I think one of the learnings from, for example, the Somali community is that if you have a dispute resolution system, as much as you agree to it, but if it's outside of the South African legal system, that you cannot enforce it, it then becomes an empty system. and you're acting outside of the applicable legal system. So yes, the MMAC would conduct an arbitration. It will be governed by the Arbitration Act, and if you want to enforce an award that you receive, you can make that award in order of the court and then enforce it through the normal processes. And that is very, very important in any appropriate dispute resolution system. You want finality. You don't want people to be using that, spending money on that, and then still going to court and litigating continuously on their disputes.
Ashraf, if I can just go back to the Somali community. In many Muslim communities, you have informal mediation that takes place on a day-to-day basis. There will always be people that are respected in the community. If disputes arise between businessmen, if there is a matrimonial dispute, you will always find somebody in the community that will act as a third party to try and resolve this dispute. So the whole concept of mediation, and it's an old concept, I mean, it's from Nabi Sallallahu Alaihi Wasallam's time. That kind of system has always existed within the Islamic community and Muslim community.
So what you're saying is that it's like almost natural to have mediation because it's almost natural to have disputes. On that point, I can ask you to please pause there. We're going for a short ad break and we will be back after the break. Assalamu alaikum and welcome back to the second half of Legal Ease. Tonight we are discussing the question of using mediation as a tool in dispute resolution, and I'm joined by Afzal Mosam, an advocate, and Ebrahim Patelia, an attorney. Afzal, just before the break we were talking about the natural disposition of people to mediate in disputes. Now, what kind of mediations could one possibly have? Because it appears to be quite a wide area that it can cover.
Well, I mean, in any sphere, in any business, there's always going to be disputes. You have your typical labor disputes, your unfair dismissal disputes. You have disputes relating to commercial disputes. I mean, I did a dispute between two major motor vehicle companies relating to the sale of a subsidiary in South Africa. We've mentioned already, matrimonial disputes. You would have disputes relating to intellectual property, for example. The use of a slogan between two telecommunication companies. Any form of dispute can be subjected to mediation. That's the point we're trying to make.
So Ebrahim, there's a clear difference between what mediation offers as compared to arbitration as a process and litigation. So let's just unpack those three differences. Is there a difference between the three processes?
I think that's a very important question because we often get that confused. Mediation is per se a negotiation between disputing parties that effectively is facilitated by a third party. I always imagine it as a pot of conflict. A husband and wife has a conflict. What we know they should be doing is sitting down, talking about it, looking at what the issues are and finding a resolution to it. But sometimes the temperature is just a bit too high. And then we try and implement good communication, but because of the sentiment, the anger that is there, it's just impossible. So what a mediator does brilliantly, he adds a special conduit. He gets the people to act out what would be appropriate in that situation to resolve their conflict. So he helps them. He helps them, but without making a decision. And I think that's fundamentally important in mediation. Mediators don't sit there and say, I tell you what to do. Guides them along, nudges them. We say nudge them along, coaches them on how to communicate, how to listen. I think that's the fundamental barrier in conflict is people stop listening. So the mediator forms a very important conduit to help parties to resolve their own conflict. Arbitration is a process where parties would go there, very similar to a court process, but without the legal formalities. You know, there's no rules of court unless parties really want that imposed. They select a person of their choice who they want to resolve it. they set their own terms of reference as well. They can decide that they want the arbitrator to find not more than, assuming, hypothetically in a civil claim, not more than 5,000 rand compensation. They set the boundaries. Or they can say, well, you can find anything in terms of what the law allows you to. But essentially, what the people need to do there is that they need to present evidence to the arbitrator. The arbitrator considers that evidence and makes a final and binding decision. And that decision needs to be sound because it can be tested on review before a court of law. Okay. Whereas mediation typically won't be tested. Okay. There are possibilities, but we won't go into the technicalities. But essentially, there's where parties sign an agreement and it comes to an end. Court processes is what we are very used to. If we go, most of us go to a lawyer, we are typically advised these are your options in terms of law. These are the court processes available. And effectively what happens there is that you are bound by a system. One person very aptly describes it as a procrustin bed. I think, in ancient Greek times, is that you have a defined bed. So you're going to fit your particular dispute to what's already defined. If you're too tall for it, they cut your feet off. If you're short, they stretch you effectively. But you're going to have to find a basis in law in terms of our court, our legislation, and also the rules that are applicable. It's not adaptable. It's there. And effectively what's going to happen is that there's going to be a paper process between the lawyers, which is defined in terms of our procedural law. And eventually you're going to get to court, lead evidence, and a judge is going to make a binding decision. The difference being to arbitration is that it can be subjected to review and an appeal process. Okay. It's also a very lengthy process. So when we look at...
there's a cost in terms of time,
yes,
and in terms of money.
Yes.
But before we come to that
there's
point...
another cost.
Yes.
The emotion involved.
Yes.
The emotion involved in litigation, you would know as lawyers, and I'm sure many of your viewers, many of them are involved in litigation.
At this point, we're going to invite them to call in. As usual, our number is 011 086 7701 2 or 3, and the number appears on your screen. So, Afzal, on the point of the emotional cost, there is legislation dealing specifically with divorce mediation now. And Ebrahim, I know that you are intricately involved with this, and you've set up a training program. Now, how does that impact on the divorce process as such?
If you look at the number of divorces, Ashraf, and I think any lawyer would tell you that it has increased drastically. Okay, and it's not just limited to the Muslim community. It is a phenomena that is apparent all over the show, and we don't analyze the reasons why.
Yeah.
But the fact is that is an area where people typically, and are in a very personal relationship. Obviously, they have children, they have a partnership, which is a financial arrangement, and overnight, virtually, it is broken. Suddenly, the children are left without a mother, perhaps. They taken by the father. Assets needs to be distributed. And what people tend to do is would go to court and they go through the process. And we as lawyers know that it's amazing how love turns to pure hate in that kind of situation. And that is a situation which absolutely requires people to sit down and think through how they want to resolve what is a very personal relationship. Because if they're going to go to court and leave the decision to a judge to decide who's going to have parental responsibilities for the children, the judge is going to be isolated from the personal dynamics. So what the Children's Act does very wisely, okay, is that it allows parties to develop, and parties being the parents, okay, to develop a parenting plan, as an example.
Yeah.
And we find a gap in that when parties, that husband and wife can't resolve that between themselves, there's a section in the Children's Act, Section 33, allows them to either go to the family advocate And simply
But
put,
the family advocate's office is usually very, very busy,
absolutely.
backed up for a long time, and with very few social workers.
Yeah,
Ibrahim, I just want you to pause there.
sure.
Afzal, you spoke about emotion. I mean, emotion is such a critical factor in all of these negotiated settlements. I mean, we've seen it in the area of politics or personal conflict or in commercial disputes. How does one manage emotion? I mean, here you're the mediator. You have certain skills. The parties trust you and they have confidence in your ability and they know that the process will carry confidentiality. Let's just speak of confidentiality first.
I think let's unpack the process. I mean,
Yes.
the process is a very simple process. Firstly, parties must trust the mediator.
Yes.
So what ordinarily happens is a mediator would get chosen by the parties. Okay. So take, for example, in the platinum industry. I mean, I've been doing platinum and gold for quite some time. So you develop a relationship with the parties over the years. So whenever they have a dispute, they would call you to deal with that dispute. Now, the process is such that as the mediator, you would outline to the parties that you are in control of the process. And there is always emotion involved. You would have a situation in a labor dispute where it's in the middle of a strike, and as the parties convene in the plenary, and
just make that simple. What is a plenary?
a plenary is your general meeting, your meeting room, where you as a mediator get both parties to explain to you what the dispute is about. So you would get them in the same room. You would get toying, you know, it would get sometimes where you would get sometimes situations where people would cast aspersions at each other, insult each other.
So it's quite a difficult job. I mean, you have to be independent. You have to be listening to two very opposing views. There's high emotions. There's maybe aspects of racism. There could even be physical danger. You have to deal with all of these issues.
That's why they don't pay us enough, but that's a topic for another
No,
day.
they do pay.
The point of the matter is you would then decide how you're going to deal with the process. Now, what a mediator would do under those circumstances is you would separate the parties to take away that emotion.
So you're talking about like a physical separation
Correct.
in different rooms. So
Yeah, we call it
excellent tactic.
different caucuses.
Right.
Those caucuses are confidential. As a mediator, you cannot disclose anything in a private caucus without the permission of the party you are
So
having
on a practical
discussion.
level, you'll visit one party, you'll make notes in your head, or you'll keep some kind of record of what is confidential, what they would expect you to say, what positions are they prepared to give up, and then you would go to the other side and you would assess the same thing.
Correct.
Right.
It's well, simply a negotiation taking place between two parties
Right.
through a third party.
Okay.
So you got to manage that negotiation between
So
the
I
parties.
take it that's similar in the divorce situation, Ebrahim. I mean, divorce is a lot more emotional. There's children, there's proprietary rights, there's the whole trauma of breakup and of course, financial difficulties that come with the separation because there might be two households and not enough money, etc. I take it that you also have to go through this process of trying to dampen the anger. And so what would be the mechanism that you would employ?
Of course, the divorce mediation is pretty unique in terms of the emotional level. But the unique part of the model that is applied in divorce mediation is that you don't separate the parties unless it's absolutely necessary, because the trust is so fragile in that there's so much suspicion between that husband and wife who's now at the point of breakup that if you go and meet with them separately as a matter of course, they actually don't trust the mediator.
So it's interesting. You have to keep them in the same room.
You
But
keep them.
that's a fundamental
Different.
difference
Yeah.
between your commercial disputes,
Yes.
your labor disputes, and what Ebrahim
It
is
is.
now explaining in terms of your matrimonial disputes.
But the unique part of mediation is what Afzal made the point earlier. I think what makes a good mediator is your instinct and your ability to understand, now I need to separate parties, now I need to keep them together. So even in a divorce mediation, there's a possibility to separate parties, but ideally you keep them together. But unlike what we do in employment law, we can mediate for 3 days in a row and 3 nights in a row, and without sleeping, and that tends to happen, is that in divorce mediation, you can't go more than an hour and a half. So if a person's going to come to divorce mediation, because of the intensity of that,
Yes.
we need them to be rational. As much as we are rational, if they are depleted, and they usually get depleted within the first hour, then you have to call it a day. And typically it takes between 3 and 6 sessions in divorce mediation to get finality. The other unique element of divorce mediation, which is very important, often people come to divorce mediation, and I've called it divorce mediation,
Yes.
believing that you're going to assist them to reconcile.
Ah.
Now, unlike labor disputes and commercial disputes, there we look for opportunities of continuing the relationship if they exist. In divorce mediation, the first question we ask that couple, have you decided to divorce? If they say yes, now we're in the territory of mediation. If they say no, then we're not the right people for their job, because then they need to go sit with a psychologist or a counselor, someone appropriately trained to help them bridge their relationship problems, whatever other problems, to help them continue.
That's quite a
It's very
startling
important,
difference,
yes.
and important. I believe we have a caller on the line. Caller, can you hear us? We'll come back to that call. So I think you made a very, very important distinction between mediation in divorces and mediation outside divorces. And fundamentally, it appears that in the divorce, because of the intensity, the parties are not separated, and you're not there to find the solution.
Mm-hmm.
As opposed to in the other areas where you are a conduit, where you ask people to try and consider what is important and try and let the parties find a solution to their own problems. Afzal, you obviously have some very, very interesting stories. I mean, can you tell us about one of the, just, without really mentioning names, what was the most interesting mediation that you had to conduct?
Well, I mean, there have been a number of disputes, but if I take my early days, probably the most interesting divorce I had is with regard to a professional hunter. There was a lodge in Zanin, and the professional hunter was going out with the lodge owner's daughter.
Oh.
And he wasn't too happy about it. So he dismissed the hunter. And it became apparent during the mediation that he had no intention of paying him any money as a settlement in an unfair dismissal dispute. So we settled on a hunting package.
Oh.
So that's probably the most interesting one I've had. The more intensive ones would be your strike disputes, your disputes in the public sector, mining industry, in chemical industry. Those are national disputes. They have an impact on the national economy, like the platinum industry is having at the moment. And there is a lot of tension, and it's a very stressful process,
Right.
those kind of processes.
So just to remind our callers that the lines are open, and the number to dial is 011 086 7701 /2 or 3, and the number appears on your screen. Ebrahim, just to come back to the managing of this process that we were talking about, where as inflamed as the situation is and as emotional as the parties are, they remain in the room. Now, isn't it intimidating for one party? Let's say you're dealing with a very difficult marriage, and the one party is totally intimidated. How do you then coax that party to say, look, here's your opportunity to ask for what you need? I think that's the point, is to try and resolve as many disputes as possible. So if and when the parties do go to court, matters regarding their children, the visitation rights, maintenance, etc., is all sorted out. You try and help them. How do you manage that very, very difficult
So
emotional?
before he answers the question, Ibrahim will also tell you the other problem is you're not only mediating between the husband and wife, you've got the uncles, the aunties, the father-in-law, the mother-in-law. Everybody else is involved in the process as well. So maybe
So,
you
so
should
do they
explain
come
to
and
you.
like give evidence, or are they?
Well,
Well, usually to beat the other side up, but
Okay.
yeah.
I've got some experience. But I think Afzal makes a very valid point. And I want to answer the question a little bit differently and link it to something else you said earlier on. I mean, you were startled by the differences in the mediation processes that are available. So even if you go into the socio-political dimension, it's very, very different to a labor dispute. But what we find is important that people should not feel intimidated by mediation and feel that they're going to go there on their own. The one thing that we're trying to encourage is lawyers to start developing the skills to assist their clients even when they go for mediation. It's a very different pool of skills, but slowly over a process of time, there are lawyers out there that can actually advise a client specifically for mediation. Because the type of dynamics, even in a divorce matter, if you take a person, like you said, who's undergone a hell of a lot of pressure in a marriage, without anyone assisting them in advance to go into that process, it becomes even more intimidating. But there are limitations to mediation because there are difficult situations in a divorce, and there are those situations like abuse, physical or emotional abuse. And if what we always say is that if you're in a mediation and how the parties behave in the mediation is typically how they behave when they're on their own.
Right.
Because they drop down their guard and they behave just as that. The one thing we would not do as a mediator is to perpetuate further harm to any party in a mediation. As much as it is informal, one of our roles, even in a labor dispute, as much as there may be violence, but if we're there to add to that,
Yes.
then we need to stop. So practically what will happen is that if a husband, and it can happen, or a wife, now aggravates the situation to try and intimidate the other party through the mediation process, we need to draw the line as a mediator. And that may be a time to separate or call the mediation quits, because
Right.
one party is abusing the process to further harm the other party. So with mediation, there's always limits. And we as the mediators are trusted to define what those limits are, obviously in consultation with the parties.
Now, you raise a very important point in that these are not skills that you just acquire by chance. It appears to be a very deliberate process of learning. And I understand that you're trying to assist the Muslim community with the forthcoming divorce mediation. Just unpack your role there.
Okay, we've started an initiative, and it's called Mediate Works, all right? And the purpose is threefold. First is to make information available to people,
Right.
okay, so that they understand what mediation is. And this is part of the process, and we're very thankful for that because it debunks some of the myths that are out there as to what is mediation, is it really used. The second thing is to ensure that we can train...
Ebrahim, if I just ask you to pause, there
Sure.
is a caller on the line. Caller, go ahead.
I'm from Cape Town.
Yes.
My sister passed away 5 years ago, and I was the executor to the will. But then the bank took executorship. We took the will to the masters, and then the masters was supposed to give me a letter of authority. So I could go to the bank and all the places to report them, but I never got it. It's 4 or 5 years now. The bank took executorship and made arrangements with the tenants that was in the house to get the 3,500 rand a month, because there was a loan also. And now we went to the people, and we heard that the bank sold the house to the people. So what do we do? And when we took the will to the masters, the children, the 3 daughters, were still minors. And then the master said that the first daughter will be 18 soon, and she must get executorship. I then agreed with that. But she never got the letter of authority. I never got the letter of authority. The bank took authority, and now they sold the house to the tenants that in the house, and that after being paid 3,500 rand every month. What do I do?
Okay, so your question is that of a deceased estate where there was a will. Now, the master would not easily appoint a bank if it wasn't written in the will. So the way it works is the banks approach people saying, we would not charge you for drawing up the will, but they would be appointed as executors. So the role of the executor is to take hold of the assets and report the estate to the master, including reporting aspects of immovable and movable property. Now, where there are minor children, the master of the High Court and the Guardian's Fund, if they don't have a natural guardian, would take care of their share. But really the executor has to answer to the heirs. So it appears that the heirs in the estate were these minor children. And you have the right of recourse, and they have the right of recourse to go to the master of the High Court and ask him to ask this executor to account. So part of the executor's duty when selling the house would have been to approach the master of the High Court for consent. So the master of the High Court is where you start with these matters. It's a matter concerning an estate, minor children, sale of assets, and the executor being the bank. Your recourse would be to the Department of Justice. Master of the High Court, I think he sits in the, there must be a master's office in Cape Town. I'm not sure where it is. I know where the Johannesburg office is. I hope that answer helps you.
It does help me a little, but as I mean, now the house has been sold. The bank has sold the house. No money was for 2 years. The children or nobody received any money from the estate, and we were okay with that because at least the house was being paid or the loan was being paid because the bank made their own arrangements with the people. And now there's nothing for the children, and none of us received executorship. Whenever I went to the bank, whenever I went to any places, I was told to get a letter of authority. And up till now, I'm still waiting for a letter of authority. Didn't get, the daughter didn't get. The two daughters is 18 now. The one is in
Caller, let me just stop you. Only the executors received the letter of authority from the master. That gives them the ability to go and open a bank account and deal with the estate. You, who are not an executor from the will not get that letter of authority. So go back to the bank, and if necessary, if you can't afford an attorney, go and see your legal aid clinic in your area. They have very, very able attorneys dealing with these matters that will be able to assist you. If not, go back to the master on your own and make a report. Thank you for calling. Ebrahim, we were talking about the very difficult task of managing this, and Afzal was telling us about some of the anecdotal cases that he had and the settlements that he's reached. But mediation on its own is a developing skill, yes, and almost a science. Mm-hmm. And Afzal, you've done also a fair amount of training. Apart from the Somali community, you've done formal training, yeah, for various government organizations and things.
Yeah, well, I think both of us have been involved in training CCMA commissioners, community people.
Right.
But I think I just want to make one important point. I don't want to leave the viewers with a misconception.
Yes.
That only lawyers can become mediators.
Right.
I think I just want to make that
very
clear.
Important that you pointed that out.
Anybody can be a mediator. We have, like I said, informal mediation in the community.
Yes.
Ongoing.
Right.
So it's a skill, yes. It's a skill that has been developed. We use best practices, right, because of our experiences, and that is why we encourage people to attend mediation courses in order to understand the dynamic of the process of mediation. So it's not confined to lawyers.
Yeah.
I mean, I've been, some of the best mediators I know are not lawyers. So I just want to make that point quite clear.
So very important. So anyone can approach you to do the course?
No, Ashraf, and I think that's...
Ibrahim, can I just ask you to just pause on that? I'm sorry, but we have to go for a short commercial break, and we'll be back after the break. Assalamu alaikum and welcome to the last segment of Legal Ease. Just before the break, Ebrahim, we were talking about something very interesting, but I just want to bring a further aspect to this discussion. In that foreign jurisdictions like in the UK, especially in a civil matter or in a matrimonial matter, you may not approach the court for relief. You may not litigate until you've exhausted some kind of mediation or some kind of alternative dispute resolution and make a note on the court file to that effect so that the judge can see there's been a good attempt to try and settle. Afzal, what's your understanding of how that is playing out locally?
Well, similarly in South Africa, in terms of the new rules.
Right.
If
you say new rules, new court rules.
New court rules. I mean, if you don't go to mediation, and even if you're successful in a matter, the court may not grant you your costs in the matter. So this whole issue of mediation becoming compulsory, like in a labor dispute, for example.
Yeah.
I mean, mediation is compulsory before you go to arbitration. In our civil matters as well, rules are being developed to ensure that you go to mediation first.
So the public's first-hand experience of being involved in a mediation, even without your consent, is the CCMA, when you receive this notice that says, this is my case against you, and you call for a conciliation or a mediation or a conmed or some of the common joinders there. But Ebrahim, tell us a little bit more about a particular case that has brought the importance of mediation to light.
I think your point is valid, is that in the UK they've introduced it. In Botswana, they've introduced it. In Lesotho, in Nigeria, in Mauritius. I think we're probably the only country that is lagging behind in that we have rules in place, but it's not been signed formally. We don't know when it'll be signed, but it introduces mediation in some form or the other. In our system, like in the UK, it's compulsory. In South Africa, it may be a voluntary system or it may be compulsory. We're unsure as yet because there have been so much changes to this. But irrespective of that, Afzal's point is pretty valid because whether the rules are there or not or amended, the courts are starting to look at this. The Department of Justice has realized that the system is failing. The court system is failing. The reality is that if any member of the public is going to take a case to court, I'm not too sure, I don't do much high court matters, but I was told the other day there's probably a 2-year lag before you're going to get a date in court.
Yeah, even your motion court matters are not immediate. You have to apply for a date and you might only get it in 2 or 3 months.
So you ask yourself the question, in 2 years' time, do you really want to be litigating on an issue that is really important for you today? And I think that's where mediation brings the relief. Also, the courts are under pressure.
Yes.
There's resource problems. So the Department of Justice in South Africa, as part of analyzing the constitutional right to access to justice, has realized that the courts are actually not delivering that. We all know this, that the majority of people in our country can't afford legal services.
Right.
And courts, aside from the rules, judges are themselves saying it. Now, in an interesting decision that in 2010 was perhaps groundbreaking, it's not different to a lot of constitutional court judgments if you go and read them, propagating mediation, but this was in a divorce matter. And the judge analyzed the case very differently. Aside from distributing what he needed to distribute and looking at who gets what in terms of the children and the assets, he said, let me analyze how you've managed this case. He said, you guys spent close to 700,000 Rand in litigating on this matter. And the only thing you've done is made the lawyers rich. Lawyers don't mind because they would continuously litigate. That's
Ibrahim,
how we make our
I'll ask you to
money.
pause there. We have a caller.
Okay.
Caller, please go ahead.
Salam, Ashraf. Nizam here. I'm speaking from Cape Town.
Walaikum salam. Welcome.
I have a small problem for you guys there. I've got a dispute at the moment. I am, one of my employees took something from one of my briefcases, and I asked her why did she take it, and then she said no, she didn't take anything, and then suddenly when I told her that I'm going to get the cops to take fingerprints, she said yes, okay, no, she's leaving the job. Then she goes to the CCMA and she tells them that I fired her, unfair dismissal. I asked her to stay and she didn't want to stay, and told her, what about your money? She said, you can keep it, you understand? Now she's taking me to the CCMA. So what I said, okay, fine, I'll appear at the CCMA. And she mentioned the figure which she didn't know that the amount of money that I kept in the briefcase was, and then she mentioned the figure, so how did she know if she didn't take it,
Right, I hear you. So what is your question?
My question is that, look, what this thing do I have to legally, what legs do I have to stand on?
We understand.
Do I have a strong case or do I have a weak case here?
So you want to know how you must deal with this matter at the CCMA?
Yeah.
Afzal?
Well, in simple terms, an arbitration is like storytelling.
Yeah.
The arbitrator listens to a story, so you tell your story through evidence. Now,
Is that Afzal speaking?
Yes.
Yes, Afzal, can I just interrupt you? I'm sorry to do that.
no, it's fine.
One of the ladies at the CCMA phoned me earlier today to say that can we resolve this over the telephone, So I said to you, well, let's see if we can do that.
Yeah.
But, you don't know all the facts. No, we're not interested in the facts. That's what she said. Now, how do they resolve a dispute if they're not interested in the facts of the matter?
Well,
Okay, caller, we have just under a minute left. So I'd let Afzal take you through some advice here.
Okay.
look, I can't comment on the CCMA process,
Okay.
but ordinarily mediation shouldn't work like that. I mean, mediation should involve a process where you try and understand what the dispute is about, okay? But what the CCMA has done, because of the number of cases they have, they've tried to speed up the process of, and they call it telephonic mediation.
Pre-conciliation.
Yeah, pre-conciliation mediation or pre-conciliation. So the purpose is just for you, to get parties to make a decision and to try and get the matter off the roll. But ideally, that's not how the process works. Now, you don't have to agree to telephonic conciliation. You can ask for the matter to be set down, and the commissioner will follow the process that we had outlined earlier.
Okay.
Well, there, unfortunately, we're going to have to leave it. A very, very interesting topic tonight, that of mediation. Thank you, caller, for the call. And we would love to take the matter further with you. Afzal, I'd like to take this opportunity of thanking you very much for having enlightened us on the process of mediation and how it unfolds in the real world, business world. Ebrahim, thank you very much for having coming in and informed us about the process of divorce mediation and how important this is and the skills that are necessary. And we hope that people out there, lawyers and non-lawyers, would take the opportunity of getting some training to assist them in using mediation to resolve their disputes.
Thank you for having us, Ashraf.
You're absolutely welcome. And thank you. On that note, viewers, we will look forward to seeing you next week again. Assalamu alaikum wa rahmatullahi wa barakatuh.